morning, everyone. We're here for the criminal calendar call docket this morning. Today's February 1st. We have Ms. Bonilla from the state. Good morning.
Good morning, Your Honor.
All right. The first case we're going to call, I'm going to call the cases from oldest case to newest case. Ms. Woodley, we're going to skip your case of the person who's in custody until we find out for sure whether he's in quarantine.
All right, understood. I wasn't aware of that until this morning.
Okay. All right. So the first case we'll call is Joseph Ryan Lehman, 19 CT 1849.
Christina Woodley on behalf of Joseph Lehman, we are ready for trial.
All right. State ready?
Judge, the state is not ready for trial. The state filed a motion to continue last week. We had some difficulty with witness availability, so the state is asking that this case be set for pre-trial so that we can figure out the issues that we have with our witnesses at this time. For the record, I have made a counter offer and it's been rejected. This is on the age of the case that asked me to move forward tomorrow. We don't know how long this witness is going to be unavailable. Judge, the witness is the arresting officer. We were informed after pre-trials that he went on deployment for the military. He's unavailable, and at this time, because of the military deployment, we're asking that to continue this trial to a pre-trial, and that we can address it again after pre-trial.
All right. State's motion to continue is granted. We'll continue this case to February 25th at 9 o'clock for pretrial conference. Ms. Bonilla, if you could find out from, is he with the sheriff's office? Your witness?
Yes, Your Honor.
If you could find out from the sheriff's office if they have information as to when he will be available, that would be helpful at the pretrial conference.
We were instructed that he'll be ready after March 1st, but because of the deployment, it could change. So I'll make sure I get updated information when next pre-trial.
All right, very good. Next oldest case is Rashad Tyrese Mitchell, case number 20 CT 277 with Ms. Armpriester.
Judge, he's not in play.
All right, we'll recall it. All right, next case, I don't see the attorney present. I don't have Mr. Verderamo here. All right, we'll skip that one. We'll go to Jarrett Berg Smith, case number 20 CT 777 with Ms. Woodley.
Christina Woodley, you have Jarrett Smith, 202777, ready for trial. Judge, I'm not sure if the court is inclined to set on trial this week. We do have a witness that we were informed last week that he was not cleared for trial this week. So we're asking that this case either be set for another day this week for trial, or in the alternative setting for pre-trial conference.
I don't quite understand. Your witness is not available this week, but you're requesting another date this week?
The witness is not available for trial today, but he is available this week, rest of the week for trial.
Well, trials would start tomorrow.
I mean, tomorrow, Your Honor, I apologize.
Do you know what day he will be available?
He said to us that he was available on the 4th, so he got cleared by Amazon to attend trial on the 4th. Could I have a moment? Talk to Ms. Bonilla.
Yes, go ahead.
He's in lockdown. He'll be around everybody else.
Okay.
none.
All right, we'll recall it. Next case is Dylan Alexander Leon, 20 CT 1037 with Mr. Good morning, Mr. Levin. Right there is fine.
If you work out a negotiated resolution with the state, there'll be orally agreement with the end of this point. There's a resolution filed as well. We just request a 3 days that we will pay essentially 4 weeks at the time.
Ms. Benia?
Judge, that is correct. That the defense counsel said.
How about February 23rd?
That's not just,
All right, February 23rd at 9 o'clock for a plea in absentia.
thank you.
All right, thank you, Mr. Levin. You too. Next is Darren James, is it Burleigh? Ms. Woodley?
I'm sorry, Your Honor.
Is it Burleigh or Burlette?
This is the plea extension that I thought was last.
Two cases, 20 MM 1021 and 20.
This is the I apologize. Darren Burleigh, that's 20 and then 20 and then 1022. I handed Ms. Marcus handed the paperwork for the plea extension to Your Honor on Friday for both cases.
I think that they hadn't been filed, so the state hadn't had an opportunity to review them.
Oh, okay. That's great. Okay, we did not opportunity to work with the I did not. What case is that? 1022 and then 20 and 1021. Last name is Alec. And that is actually for both cases. Yes, it is.
All right, Ms. Woodley, would you like to put the offer as to each case on the record?
Correct. So for 20 and 1021, it's going to be a decrease in cost. 12 months of probation for mail-in. May early terminated 8 months. 10 days of the weekend work program. ACF milestone program. Restitution to the victim in the amount of $249.73 in trespass for classified prosecution public penalties. They already stated mail-in probation, not that was in grade 1 terms.
And the no trespass is for where?
For 20 and then 1021, the no trespass. The no trespass is for Walmart, and I believe that's for both cases, located at 5420. That's Juliet Boulevard, Maple School.
Okay,
And then it's 20 and then 1022, it's an adjudication of guilt, 12 months of probation to run through crime, also known. Early termination at 8 months if all is complete. 10 days a weekend work program. ACF milestone, and I believe that would be the same for both crimes. So I'm asking that use the ACF class for both cases. If there's no objection, no objection on this crime. And then no trespass in location for classified prosecution of public defendants.
did you get all that?
Yes, sir.
Ms. Benia, have you had an opportunity to review the plea and absentia forms?
I'm looking for the one now. On the state of review and suspension, there's no objection.
All right. Ms. Woodley, will you stipulate to venue and the factual basis for the plea in absentia in both cases? All right, I'll accept the plea in absentia. Find it knowingly, voluntarily, and intelligently entered upon a factual basis and in the defendant's best interest. In case number 20MM1021, I'll adjudicate the defendant guilty. Place him on probation for a period of 12 months. He may apply for early termination after serving 8 months, provided all conditions have been satisfactorily met. Probation may be mail-in. All court costs, including costs of prosecution and public defender fees, shall be imposed. The defendant must serve as a condition of probation 10 days jail with credit for time served, which may be done on the weekend work program, weekend lockdown, or straight time. Defendant must complete the ACF mileposts for shoplifters alternative program. Restitution will be ordered to Walmart in the amount of $249.73. There'll be a no trespass order at the Walmart located at 5420 Juliet Boulevard in Naples, Florida. Okay. Okay. Did you get the restitution on 10/21? Walmart. Okay, and then in case number 20MM1022, I'll adjudicate the defendant guilty, place him on probation for a period of 12 months, which shall run concurrent with the probation ordered in 20MM1021. The defendant may apply for early termination after serving 8 months, provided all conditions have been satisfactorily met. May do mail-in probation. All court costs, including costs of prosecution and public defender fees, shall be imposed. As a condition of probation, must serve 10 days jail with credit for time served on the weekend work program, weekend lockdown, or straight time. Is that concurrent with the other case?
Yes.
That jail condition shall run concurrent with case number 20MM1021. Defendant must complete the appropriate ACF milepost shoplifters alternative program. No trespass at the Walmart located at 5420 Juliet Boulevard in Naples, Florida. Did I miss anything? looks good. All right. The next case we have is Humberto Morales, case number 20 CT 1321 with Ms. Armpriester, who's not present. All right, that brings us to Timothy Wagner McIntosh, case number 20 CT 1340 with Mr. Carr. Good morning. Okay. Go ahead.
DUI is basically the probation, the program probation shall terminate 6 months. My client's already done the DUI school. We must know what's done.
Judge, the amended plea offer in this case is adjudication of guilt, $500 fine, 12 months probation, which shall early terminate at 6 months. DUI school, substance abuse evaluation, follow the recommendations of required treatment, no alcohol clauses, 10-day impoundment, vehicle impoundment, 50 hours of community service, where the defendant may have the option of going up after the use of $1 an hour. Victim impact panel, court costs, and cost of prosecution.
All right. Did we get everything, Mr. Carr?
Yes, indeed. I want to make sure that we're clear. It doesn't have an additional hearing that you would 6 months. Oh, it's done. So it's done on top.
Correct. All right. Sir, will you raise your right hand to be sworn by the clerk?
People are hearing.
Okay.
Do you solemnly swear or affirm testimony you give shall be the truth, full truth, and nothing but the truth?
Yes.
Thank you.
Will you state your name?
Tim McIntosh.
Mr. McIntosh, your attorney has indicated you wish to withdraw your previously entered plea of not guilty, enter a plea of no contest, and accept the state's offer to resolve your case today. That offer again was to adjudicate you guilty, place you on probation for a period of 12 months. That probation shall terminate upon the successful completion of all conditions at 6 months. A $500 fine would be imposed. All court costs, including costs of prosecution, would be imposed. You must complete the appropriate DUI school, 1 victim impact panel, 50 hours of community service, which you may buy out at the rate of $10 per hour. You must undergo a substance abuse evaluation, follow all recommendations. You'll be subject to random testing at your own expense. There would be a 10-day vehicle impoundment. There would also be a no alcohol order. That means you cannot consume alcohol while you're on probation. You cannot have alcohol in your residence. You cannot go anywhere that primarily sells alcohol, such as bars, taverns, saloons, or packaged liquor stores. Do you have any questions about the offer?
Just on that last line right there, most restaurants sell alcohol.
It would be where they primarily sell alcohol. So a restaurant would be acceptable. You shouldn't sit at the bar.
I don't know what's
Okay. Any other questions?
no.
All right. Have you signed the plea form?
So as soon as we find one, I will sign it. I've explained his constitutional rights quite a bit of detail already.
All right.
date of birth. Date today. I guess you signed it.
All right, thank you. All right, and Mr. McIntosh, is this your signature? And by signing it, you've indicated that you've read it or it's been explained to you?
I'm sorry. I think that last part.
By signing it, you've indicated that you've read it or it's been explained to you?
Yes.
Did you understand all of the rights listed on this form?
All the briefs?
Yes.
Yes.
All right, and you understand that you're waiving those rights by entering your plea today?
I'm sorry.
Do you understand that you're waiving those rights by entering your plea today?
Yes, Your Honor.
All right. Do you understand that your plea will be used against you in a deportation proceeding if you're not a United States citizen?
You're a citizen of the body.
Yes, Your Honor.
Are you under the influence of drugs, alcohol, or medication?
Am I under medication?
Are you under the influence of drugs, alcohol, or medication?
I take medication.
But is it affecting your ability to understand these proceedings?
Yes.
All right. Have you ever been diagnosed with a mental illness?
Yes.
Are you satisfied with your attorney's advice?
Yes.
Has he done everything that you've requested?
Yes.
Do you understand that DUI is an enhanceable offense, meaning if you're convicted of this crime in the future, you could be facing higher fines, higher penalties, more jail time, or a possible felony conviction?
Yes, Your Honor.
And knowing that, you still wish to enter your plea?
Yes.
Ms. Bonilla, do you have any additional questions?
No further questions, please.
All right. Mr. Carr, will you stipulate to venue and a factual basis for the plea? All right, sir, I'll accept your plea. Find it knowingly, voluntarily, and intelligently entered upon a factual basis and in your best interest, adjudicate you guilty and sentence you as previously stated. I'm going to have you step right behind you to be fingerprinted. You'll need to check in with probation today before you leave the courthouse. It's located on the first floor.
I'll walk you down.
Very good. All right. Thank you, Mr. Carr. Thank you, Mr.
Thank you.
McIntosh.
Thank you.
No? Is it on the other screen?
It was there, and you clicked and it disappeared.
Okay.
Oh, there's a count to civil infraction.
Oh. Mr. Carr,
Yes, Your Honor.
what would you like to do with the civil infraction?
Emergency dismissal, Your Honor.
So ordered. Thank you. All right, that's good. Thank you. All right, that brings us to Thomas Gilhooly, 20mm 1234 with Ms. Human. Good morning.
Good morning, Your Honor. Mr. Gilhooly is present.
All right, give me one moment here. All right,
I've actually filed a motion to withdraw as attorney of record in this case, Your Honor. There have been very recent correspondences that have made serious accusations, both about my diligence in this case and my loyalty to my client. It makes me unable to represent him at this point. Additionally, he wishes to assert defenses of the sovereign citizen type that I am not willing to assert. So I would ask for permission to withdraw in this case. And on his behalf, I would make a more tense motion to continue it to the next trial cycle, so he does have an opportunity, if your honor grants that, to get the counsel. The
All right.
facts are not complex here, and if the attorney who he chooses to hire next contacts me, I'd be happy to give them all discovery and meet with them immediately.
All right. Ms. Bonilla?
Judge, the state has no objection to defense counsel's motion.
All right. And you said Mr. Gilhooly is present?
He is present.
Okay. All right, I'll grant the motion to withdraw. We'll continue the case to February 25th at 9 o'clock. Mr. Gilhooly, if you obtain counsel by then, make sure to have your counsel file a notice of appearance and get with Ms. Human. Or in the alternative, if you cannot afford to hire a private counsel, you can always apply for the public defender's office. You can do that at the customer service window located on the first floor. And I think we'll have Mr. Gilhooly sign for that pre-trial.
And Your Honor, the second one I have in the document, I think you signed it over to the table.
Correct, it's already fallen off the docket.
Thank you.
All right, thank you. All right, let's go back to, I see Mr. Verderama's here. Omar Onelis Rosa, 20mm606.
Morning.
Good morning.
Here for the record, Mr. Rosa actually did.
All right, I do see that.
Adjudication. Cost. $308 shares of cost.
Ms. Bonilla?
Judge, the plea offer in this case is correct. The state has had an opportunity to review the plea extension. We have no objection to the documents in the record.
All right. Mr. Verderama, we stipulate to venue and a factual basis for the plea in absentia. All right, I'll accept the plea in absentia, find it knowingly, voluntarily, and intelligently entered on a factual basis and in the defendant's best interest, adjudicate guilty, impose all court costs, including costs of prosecution, as well as costs of investigation to the Collier County Sheriff's Office in the amount of $308. Does your client need some time to pay?
Yes, 60 days.
All right, 60 days to pay.
Thank you. Have a good day.
Thank you, you too. All right, let's go back to, we're gonna call them, we're gonna recall the other cases. We'll call them in the order of oldest case first. That brings us back to Rashad Mitchell, case number 20CT277 with Ms. Armpriest.
Yes, and Mr. Mitchell is present.
All right.
Warrant for the direct obligation. I've spoken with Mr. Rath. I'm not sure if the court would be inclined to their argument. Since we were back there for school.
You may.
Since we were last in court on this matter, there's no need for counsel to belabor it, but Mr. Rashad has paid all kinds of fees out of St. Lucie County and other counties to take his license. He is present today at the mandatory hearing. There is still a failure to appear on St. Lucie in case 20CT
469 with a bond amount attached. But Your Honor, in light of my client's diligent efforts this weekend and here, we're asking that Your Honor change the bond amount on that warrant. It is currently listed at $10,000.
What authority do I have to change a bond amount for a warrant out of St. Lucie County? You may.
Thank you, Your Honor. I'll point the court's direction to State v. Morris, 768, Southern 2nd, and 70 for the Supreme Court. In that case, the Supreme Court held that a judge issuing arrest warrants cannot include a perseverance judge for modifying enforced bail conditions, including changing the bond amount. And the state would make an argument to potentially modify the bond to $2,000. The defendant today puts that bond, change the driver's license, requires security for our case.
Well, this isn't first appearance.
I understand, Your Honor. Alternatively, Your Honor, if the court would be in contact with St. Lucie judge that issue warrant, potentially modify bond.
I think that would probably be the more appropriate thing to do in this case. Currently, we do have authorization to reach out to other counties regarding bonds. What was that case number in St. Lucie County?
20 CT 1469, and the judge is Jeffrey Walton Hendricks, HENDRIKS. And Your Honor, just for the court's edification, there's a companion case of 20 CR 15819. And that case was closed. I did reach out to see if my client had counsel on the matter that could only see a prosecutor. At this juncture, I didn't feel comfortable reaching out to them, but the companion TR case was closed. And for the record, pursuant to Kimberly State, my client's pledge was they're not listenable for substantial. He thought when his matters were closed that they were closed. He didn't realize there was this companion criminal case. When he was informed about it on Friday, he did pay it that day.
Okay. All right. So I'll reach out to St. Lucie County regarding that failure to appear warrant, see if they want anything changed on that. And then I'll provide that with the first appearance judge. Does anyone know who that is this week? The Judge Provost?
Yeah, Judge Provost.
All right, I'll reach out to Judge Provost about that. So what's the state's position on this current case?
Your Honor, the state would request a $2,000 bond instead of the commission of judge in St. Lucie County.
Okay.
Driver's license today. Bond is posted, he's able to obtain his license today, requires insurance later this week. Eventually resolved by case here.
Ms. Armpriester? So what, on Friday?
And any day that the court would give us a judge, I can only represent the court that is committed to doing everything he can get.
All right, we'll continue the case to Friday at 9 o'clock. Mr. Mitchell's presence will be required. At this time, I'll remand him to the custody of the Sheriff's Office on the St. Louis room. Briefly. That's up to the jail.
Thank you, Your Honor. Okay.
All right, next case is Jarrett Smith, 20 CT 777 with Ms. Woodley.
Judge, statement,
You may.
can we have an opportunity to discuss, there are only 2 cases on your docket, which are at this moment priority for trial this week. If I can confirm with Ms. Woodley for 5 to 10 minutes, then we can determine whether we're proceeding the trial or whether.
All right. Well, let's address, Ms. Woodley, let's address your other case then. Candido Cruz Rios, 20 MM 1182. Mr. Cruz Rios is not present. I've been informed by the jail that he's currently being held in isolation.
Yes, and that would explain why I did have a hard time reaching him. I did speak with him and he would like to accept the offer. I talked to him on Friday and this, I would like to set this as soon as possible for me. I believe when this, long story short, when Corona first hit, they were able to put them in some sort of gear to let them have a pretty honest screen. And we were still able to put people out even if they were in quarantine. I don't know if that's the case. It could be wrong if they have to wait for 14 days. Either way, I'll have to reach out to the jail, but I do not know that he was in quarantine. But he for today's purposes, he would like to accept this offer.
All right. So how about if we continue it to the next pretrial conference? You can work out with the jail and put it on maybe a 2:15 docket, or we can do a special set if need be.
Certainly, I'm hoping to get him on this week.
Any objection?
No objection.
All right, we'll continue to February 25th at 9 o'clock. All right, and so Ms. Bonilla, you need an opportunity to speak with Ms. Armpriester and Ms. Woodley regarding the 2 cases that are left on the docket.
Yes.
Okay, we'll be in recess until you let me know. to Jarrett Smith, case number 20 CT 777 with Ms. Woodley.
I was just like, we'll just on behalf of Mr. Smith in case number 20 CT 777. We are ready to proceed with trial tomorrow.
State,
I have a question. Your Honor.
you may.
Thank you.
Good morning.
Your Honor, this case, the city had previously announced already on this case. It was our understanding before this morning that there would be a separate case proceeding to trial. Offers were extended to the public defender's office over a week and a half ago. The state had not had contact on either of those cases. The state re-extended that offer on the domestic violence case earlier this morning that resolved. The civilian witness that is unavailable tomorrow on behalf of the state is a truck driver who lives north of Tampa. The state did not see it fair to tell him that he was going to be needed to request off for tomorrow if it was the state's impression, based on the lack of communication with the public defender's office, and we would be proceeding to trial on that case as he would be losing money. That civilian witness has stated that he's available for trial later this week on Thursday. However, the state does need to confirm that its arresting officer is also available. The state believes that it can do that today and give you an update later this afternoon.
Your Honor, we're set for trial call. The state is, I'm sorry,
You may.
this is trial call. The state said they're ready. They are supposed to be ready with their witnesses today, like Ryan. I do not think it is fair for my client who is taken off work, who drove from the East Coast, taken off work on the arrangement. I'm sorry, he didn't drive. He found a ride here. He had to pay for a hotel here last night into tomorrow. For the state to say they were expecting another case to go to trial, that is not fair to my client. And they said they're ready for trial. They should have come ready with their witnesses for today and tomorrow.
Your Honor, the state may respond.
And if I could say one further thing.
Go ahead.
I have made a counter offer. It's been rejected by the state. So
That's up to the state. Go ahead, Mr. Rabin.
Thank you, Your Honor. Your Honor, yes, the state did reject that offer numerous times over the past week. As the court is also aware, Ms. Bonilla has placed on record multiple times the lack of communication that we've had with Ms. Woodley as relates to cases on this docket. While it may be unfair to the client, that's certainly not the state's fault. Again, based on the circumstances, Your Honor, the state is ready for trial later this week. The court will indulge. We just need to confirm that our arresting officer is also available. We do believe we can do that today.
I don't understand why you don't know whether he's available this week or not.
Our arresting officer, Your Honor, is also a student in addition to being a state trooper. We just want to make sure there's no additional conflict.
He's under subpoena, correct?
He is, Your Honor, for tomorrow.
Well, for all week, correct?
I believe the subpoena was for tomorrow.
And until the court releases him, correct?
Yes, sir.
And I did double check the subpoenas for all witnesses were for tomorrow, and that's why I'm asking you to move forward with the trial for tomorrow as scheduled.
Ms. Woodley, do you plan on calling any witnesses other than possibly the defendant?
Just my own client.
And before I make a decision in this case, do we know what we're doing in Ms. Armpriesters' case?
Your Honor, I made that with the client previously. The state has told me that we will address it once they know what the status of the proceedings is. So
Well, I mean, is it proceeding to trial?
I am ready for trial.
I think they are dependent on one another, Your Honor.
I'm sorry?
I think they are dependent. I think the decision in this case will potentially force a decision in the other case.
Judge, I can't get that. I can't get an answer on what. I and my client are ready for trial. We're ready for tomorrow. We're prepared. The state hasn't indicated one way or another until this case has some sense of direction.
If it is the court's intention to continue Ms. Woodley's case to Thursday, it would place the state in a different posture from Ms. Armpriesters' case if the court wishes to set that tomorrow. However, if there's only going to be one trial this week, the state is then in a different posture. I don't want to put anything on record that the state is not currently in a position to state one way or another.
Right. On Mr. Smith's case, how many Are we expecting this to be a 2-day trial?
Just a one-day trial,
Well, remember, we have
but
COVID procedures that we have to follow.
if we get a jury panel on first try, one, probably it'd be safe to say 2, just in case it takes.
How many witnesses does the state intend to call?
The state intends to call 3 witnesses, Your Honor, in addition to the civilian witness who's unavailable tomorrow. There are 2 law enforcement officers.
So that sounds like a 2-day trial. Are there any interpretation needs from either side?
No, Your Honor.
Have all motions been heard?
Yes, from defense.
The state has no motions filed.
DUI, first offense, we don't have to worry about a bifurcated trial.
That's correct.
Agree, Your Honor.
Is there any need for any special jury instruction in this case?
The state is more.
Okay.
No, Your Honor.
Are there any stipulations or concessions that either side is willing to make in this case prior to trial? That's maybe a defense question, but
No.
okay. Will audio-video equipment be used in this trial?
It will, Your Honor.
And is the state ready for that, those technology issues?
The state does plan to use videos and redactions will be made with the facilities knowledge beforehand.
They have not been provided at this point to me,
What hasn't been provided?
the redactions.
When will you have that available for Ms. Woodley?
Your Honor, we can make those available to her later this afternoon, perhaps tomorrow, at the very latest.
I would ask that they would be by this afternoon, so I have a chance to go over them with my client before tomorrow, if that's when we're going to be proceeding.
All right, we're going to grant the state's request. We'll start trial 9 o'clock on Thursday. This room, as you may recall, will be used if you received the COVID procedures.
Yes.
Ms. Woodley, Ms. Bonilla, you received them.
Yes, Your Honor.
All right, Mr. Rabbit, didn't include you on the email.
I have not, Your Honor, but I'll touch base.
All right.
Just on Thursday, we're moving to the court. You said Thursday.
Yes.
And Your Honor, I do want to confirm, the state does want to confirm the availability of the arresting officer for Thursday.
Well, you'll have to file the appropriate motion if you need a continuance, and then we'll have to address that.
Yes, sir.
All right, any questions?
Is the state announcing they're ready for trial on Thursday, or?
We are having trial on Thursday,
Okay, wonderful.
unless a motion to continue is filed and ruled upon, stating otherwise. Don't forget, this room will be used as the jury assembly room. So you'll have to wait outside until you're called into the courtroom. Okay. Any questions about any procedures for Thursday?
No.
Okay. All right. Smith will have you sign for Thursday, okay? All right, thank you. Okay. Ms. Woodley and I guess Mr. Rabb, one alternate?
Yes, sir.
Yes, sir.
Okay. Okay. While we're,
Judge, if you have a seat, and I'll come back to it.
okay. All right.
I just want to have a seat, it's gonna take a minute.
All right, that brings us to Humberto Morales, 20 CT 1321 with Ms. Armpriester.
Yes, Your Honor, once it's ready to proceed with trial, I have filed my motion in limine, and requested a hearing time this morning. The state, Mr. Rabb and I have, as well as Ms. and I, we have discussed it. I don't believe there's anything that they would object to.
Right.
And Your Honor, I'm not sure if it's as much of an objection as it is clarification for each of the points in Ms. Armprister's motion.
All right, is the state ready to proceed to trial?
It is tomorrow, Your Honor. No, is the intent to only have a single trial this week?
Well, I informed the state attorney's office that we would be having trials this week, whether it was 1 or 2 or however many we could get in.
If the state is not ready to proceed tomorrow, Your Honor.
The state is, are you saying the state is not ready to proceed tomorrow?
Correct, Your Honor.
Why?
Your Honor, there may be additional evidence that the state would like to obtain in the form of medical records requests. And outside of that, if this case is set, then the state may make announcements.
Your Honor, this is the literal first time that I am hearing about a medical records request. We had court last week where the state announced ready for trial. This case has been around since July. So if we've got to this point where they want to have evidence, I believe the appropriate step at this point is a Richardson hearing. My client was here for nearly 2 hours this morning.
Again, Your Honor, I think the Richardson hearing will be dependent on whether or not we're proceeding to trial tomorrow on this case. Again, if that is the court's wish, then the state will need to make an announcement. The state will file the appropriate motion and is ready to argue Mr. Armprister's motion today.
Well, the state did announce ready for trial. This case is 200 days old. The court has reviewed the court file. I don't know why the state can't proceed without medical records based on the allegations in the booking report.
Your Honor, the state does believe that medical records potentially are necessary to prove one of the elements of the crime that the defendant is being charged with.
Is there a reason why the state didn't seek those before?
Unclear, Your Honor. Apologies on behalf of the state.
Well, are you moving to continue this case then?
That would be our request.
All right, motion to continue is denied.
In that case, Your Honor, is it the court's intent to set this for trial tomorrow?
Yes.
In that case, Your Honor, the state announces an overall case 2016 for
Right. All right, is there anything else we need to discuss regarding trial been set for Thursday or anything else?
Your Honor, if there's any update from the judge in the 19th Circuit, would you please include myself in this case so that I can communicate with Mr. Mitchell as soon as possible?
I will, and just to let you know, I did send that email to, I think that's the 19th Circuit, to the appropriate contacts there. I did also copy Judge Provost's judicial assistant on that email, and if I hear anything back, I will forward that to both of you as well as Judge Provost's office.
Thank you very much.
All right, thank
Your
you.
Honor, I just request this I just request that this go to the individual on behalf of the state to receive it.
All right, that'll be fine. All right, anything else?
No, Your Honor, no,
All right, that'll conclude today's calendar call docket.